Thank you all so much for being here. I do appreciate you taking the time out of your afternoon. I know this is a 90-minute webinar, but I will do my best to keep it fun or interesting. And I'm sure you guys are sick of PowerPoints by now in this COVID Zoom world, but I only have like 5 slides for you, just in case you want to take notes. So it's not that terrible. So Michelle and I are Florida business attorneys. We have a practice. It's called Florida Entrepreneur Law. We represent business owners, businesses all the way from startups to multi-million-dollar companies. And we specialize in entity formation, as well as joint ventures, franchises. We work with real estate investors to set up their entities and whatnot. But we're also litigators too. So we're not just corporate attorneys sitting there drafting contracts and agreements. We're fighting for you in court. We know how to draft agreements in a way that will keep you out of litigation, or at least have a defense and protection during litigation. So that's a plus. But Michelle, you want to take it over? Because I know your time is limited.
Sure. Thank you, Amanda. And thank you everyone for being here. We're super excited. Amanda's been talking to me about REIA forever. So I'm really excited that, she's got this opportunity to speak with you all and genuinely help you in avoiding the legal pitfalls, as the title of the seminar is named, because you don't know how often, we have clients come to us and we wish we had been there before to help them drafting their contracts, or they had taken the right steps to avoid litigation in the first place. The good news is that you're going to walk away today with a wealth of information, so much more than you could possibly ever get, I would think, in many other seminars. We like to approach things from a pragmatic, realistic point of view, and we communicate things in a way that you can understand. We are not hoity-toity lawyers that need to use high complex legal jargon. We get to the point and we're no BS. That being said, yeah, as Amanda said, we are a business-focused law firm. We represent everything from real estate investors and developers to construction companies to e-commerce and CBD companies. We've been doing this for a while. Both of us come from a big law background, which means that you get the expertise and experience that comes with that, with a much more reasonable price tag. Now, that being said, we love to give you a prophylactic approach when it comes to your businesses and help you prevent issues before they arise. We're happy to have you here. Sorry I can't stay longer. I have a newborn inside, which now dictates my schedule. As you can see, I'm coming to you from my fabulous Volvo. But I'm super excited. I know Amanda's super excited, and I'm gonna hang out as long as I can. And like Anish and Ryan said earlier, if you guys have any questions, please don't hesitate to reach out after the seminar. We'd be happy to help you with those questions.
All right.
And I'll turn it back to you.
I see in the chat already, do we represent construction roofing companies? Yes, we represent any kind of company. If you're a business owner.
And what I was going to say today, what we're kind of doing exactly what Amanda was talking about. I know some of you guys are sick of the PowerPoint. So today is really about you guys. So there's some basic topics that we're going to kind of go over, and then we're going to kind of, I don't know, wing it a little bit depending on what you guys want, meaning it's your seminar. And Amanda, don't worry, I'll keep an eye on the Q&A. So don't worry, I'll stop you in a second so you don't have to worry about it. You could just kind of share some of the things that, you actually see in investors. I know I always get this question, right? The first question is, I'm a new investor, right? What kind of entity should I, basically set up?
Yeah, so that's what this webinar is pretty much going to be about, is what is the proper entity structure to choose for your real estate deal? What are the liability protections and risks involved with each type of entity or structure that you choose? So let's just, can we actually do a poll to see how many people are already investors or just want to?
Yeah, so go ahead and in the chat. If you're already an investor, right? So we're going to start as an investor if you actually own at least one property besides your home, or if you flipped a property. So that's what our definition of investor is. So how many of you guys are investors? Put yes. And if you're not, no is okay too. You're also at the right spot, meaning you're going to learn how to set up the right, organization or entity before you start doing deals too. So we got a bunch of yeses. I got a couple of vacant lands. I got a not yet. I love the not yet too, by the way.
I know, I love that.
So it's kind of a bit of a mixture.
What'd you say?
It's a little bit of a mixture. We got I'd say about half and half.
Okay, great, guys. So I'm gonna go through, we'll start by going over how real estate investors should structure their business entity. And then we'll talk about the benefits of an LLC, single member LLCs, multi-member LLCs, annual reporting requirements for your business, articles of organization and operating agreements, which are super important to have for your business, asset and liability protections, the Florida LLC charging orders, also liens and protections with that. And I want to definitely go over the understanding the Florida as is real estate contracts, and then talk to you about why you should consider having an attorney for your real estate closings for your investment properties. So let's start by going over how real estate investors should structure their business entity. So
and before even we get, so some of you guys are new, and I know there might be terms you may or may not know. Take a deep breath. Today is an overview, right? Today you're not becoming a lawyer. This is why you want, our new corporates to protect you. So if you don't know, that's okay. It took many years to learn some of these things. I hear it over and over and over. So, hang in there, guys.
Yeah, and I'm not gonna use legal jargon. I hate it. I don't like it. I don't even remember what all the terms mean sometimes. We're just gonna have a conversation. And if you don't get something, if you don't understand, write a note down and then let's talk about it later, or leave a question in the chat, but it won't be too painful. Okay, so owning investment properties, it's exciting and it can be lucrative, right? But investments in real estate, whether it's Airbnbs, long-term hold, rental properties, if you're doing a rehab and you want to flip, they all create serious liabilities, which is why it is so important for investors like yourselves to understand how to properly structure your businesses. So, for example, if you own a rental property and your tenant trips on an unstable staircase, or your tenant's guest slips on an uneven sidewalk on your property, or there's faulty electrical wiring and it causes a fire, literally anything, or you own a condo, your tenant's renting and there's a plumbing issue, it causes mold in the property, you don't properly remediate it, tenant develops health issues. All of these accidents are likely to lead to a lawsuit against the property owner. So some business structures such as sole proprietorships, general partnerships, they leave property owners personally liable or personally responsible if someone sues for damages caused at a property that they own. But there's other business entity types that offer some level of personal liability protection. And this is important because without personal liability protection, your personal bank accounts, your stock accounts, I'm not sure about crypto yet, but I'm sure that's probably coming soon. Your home and other investment properties, they may become vulnerable to cover your legal fees, your settlements, and if it goes to trial, a jury verdict. So depending on the business structure, there's also tax implications. And I just want to say, Michelle and I are not tax attorneys. We work very closely with tax attorneys and accountants to get your deal squared away, your entity set up. But so I'm not going to give you guys tax advice, but I will share the knowledge that I do have about it in terms of tax implications and statuses that you can choose depending on your business structure. But depending on your business structure, there are certain tax implications that may affect or impact your bottom line when you're talking purchase price, just your overall deal. So this is why it's important to build your team of licensed professionals to handle your transactions. And that would include your lawyer and your accountant. So I'm going to run through the advantages of creating an LLC entity type. And I have here my little PowerPoint share. Okay, can you guys see this?
Yep, we're good with that. Go ahead and type in also in the chat. What do you think some of the advantages are?
Yeah.
Oh man, it kind of goes over it. But I think one advantage is so I could have a cool name for my company.
Yes, you can pick your entity name for sure, as long as it's available on Sundays.
Absolutely.
All right. So the first benefit or advantage is the LLC is a separate legal entity from its owners, so it limits personal liability. So if your LLC business is subject to any court rulings, debts, or losses, your personal assets are protected. Likewise, let's say, let's say someone sues you personally because, I don't know, your dog bit their kid, right? And it caused serious bodily injury to the child. The parents are likely going to sue you for damages, but they can only sue you individually, right? Not your LLC that holds ownership to your assets. So it affords liability protection in that way. The second reason you'll see here, by default, an LLC is a pass-through entity. However, you can elect an S corporation tax treatment. And so what that means is a pass-through entity is a business that does not pay income tax of its own, right? So instead the LLC's income, losses, credits, and deductions pass through to each business owner's personal tax return, where its profits are taxed according to each owner's individual income tax rate. So the S corporation tax treatment is beneficial because you're only taxed once on properties received through the LLC, as opposed to like a corporation entity type. And assuming that your primary objective of at least one of your real estate businesses is to buy, rehab, and sell a property or properties within 1 year, the IRS can consider that to be what's called an active trade or business. And so unlike passive income, the income from an active trade or a business such as flipping houses is subject to, I think it's 15% tax, which is commonly referred to the Social Security and Medicare tax. We all know what that is. So if you want to reduce that self-employment tax to a minimum, an S Corp LLC is the best entity to use for flipping houses because it's the only entity structure that allows the business owner or the investor, you, to take what's called a reasonable salary that is subject to the Social Security and Medicare tax, and then take the remaining profits out as distribution, and that's not subject to the self-employment taxes. So let's say you do a flip, you have $60K in profit. Your reasonable salary for your work, your labor, your time put into it, maybe you pay yourselves $10,000 for those 90 days that you're doing this flip. If you want to take a distribution following that flip, following closing, that additional $50,000, that's your distribution, you can take, and that's not subject to the that's not your reasonable salary, it's your distribution. So it's not subject to the self-employment taxes. So that's another reason why investors always go with the LLC and elect to be taxed like an S corporation. Also, forming an LLC is relatively cost effective and it's simple. You choose a name for your LLC, right? You search on sunbiz.org to see if that name is available. And if it is, you pay the $125 to register your LLC and you file your articles of organization. You don't necessarily need an attorney to set up the LLC on Sunbiz because the website does walk you through step by step. However, you will need an attorney to draft your operating agreement either before or after your LLC is set up. And I'll cover operating agreements and we'll talk about all that in a few minutes. And then you get with your accountant, you apply for your EIN and you're good to go. Your entity is formed and you're ready for business. And then another advantage, the LLC has flexibility in how it distributes its profits among the owners or members. So for an LLC, they're not considered like owners of the business. You're technically called members. So it's your, instead of an ownership interest, it's like a membership interest. It's one and the same. Distributions do not have to follow the percentage of the owner's monetary investment or their membership interest, right? So members may be compensated according to their involvement in running the business instead of based on only the funds they invested in the LLC. So for instance, let's say you and your partner, you're doing a flip, you invest 50,000 of your own capital, your partner invests only 20,000, but your partner is investing labor, more labor than you. They're working, they're doing day-to-day, they're running the business, they're managing the flip, they're acting as a property manager. Your LLC's operating agreement can set forth the way in which, or the percentage that you each can take in your distributions. It doesn't have to be that you get the percentage of your ownership interest in profits, and then your partner gets the in profits the percentage of their ownership interest. You guys can structure it however you want to.
And Amanda,
Also,
that would be laid out in the operating agreement, correct?
Exactly. Yep. Okay, so pretty much the trend that you probably see, LLCs with an election of a S Corp tax status are the most common business entity types used for real estate investing if you're flipping, even if you're holding and you have rental properties. I'm going to stop sharing.
Sure.
Sharing.
So
Okay.
I do have a question. Karen's asking, what's the best type for a startup if you're starting wholesaling? So you're not gonna hold anything. You're just gonna buy and sell, get stuff under contract. What would you? Again, we're gonna start with, so everyone knows this is not legal advice because every situation is different, because you may have some other things going on personally, other companies, properties. So we're gonna kind of general stuff. If you want actual legal advice, again, we have to give you that disclaimer here. So
For sure. Thank you for that. All right. So if you just want to wholesale, I would still do an LLC, right? Like I'm an investor too. I have an LLC. I put my ADI Properties LLC on the purchase and sale agreement while I'm holding it in between wholesaling, right? Because you don't know what could happen, what could go wrong. I don't want to be personally sued for anything. So if something goes sideways during this inspection period or whatever happens, and then someone goes to sue you, they're not suing you. They're just going to sue the LLC. If the LLC has no value, if it has no assets because you're just starting out, you don't own anything, there's no, income coming in, there's no liability on your part personally, is the main point. But just form an LLC and use that to hold or to put on the contract until you wholesale it.
yeah, and my question actually is this, right? And you guys are attorneys and you probably see this all the time. I know you mentioned sunbiz.org to set up a corporation. I know it gives you steps, but what are some of the common mistakes that you see when people are like, oh yeah, I just signed up and maybe I got an EIN number or what to look for?
Michelle, you may have stories too.
I was just gonna, chime in. Some common mistakes are people assume, because they searched Sunbiz under existing corporations and entities, oh, this, this company name is available, this isn't an issue, but they didn't search under fictitious names, or they didn't search under trademarks, because you may run into a trademark issue depending on how you're holding yourself out as a business. So that's one common mistake that we see. Another common mistake that we see is people love to come to us and say, well, I have this issue with a silent partner. And we're like, what exactly is a silent partner? Because that's a term you made up. That's not a term that the legal world recognizes. Oh, well, my partner is a member, but we just didn't list them on Sunbiz because we didn't want anyone to know. Okay, well, do you have an operating agreement or some type of formal document that identifies this person as a partner, an owner in the business? Well, no, they just gave me the money. And oh, so you have a loan for money to pay you back interest. Oh, well, and it turns into a whole thing. So again, just because Sunbiz says something doesn't necessarily mean that that's what it reflects from a legal standpoint.
Yeah, I was going to say, like, one of the things I noticed is that it only becomes an issue when things go wrong, right? Like they got that silent partner, all those stuff, and I lent the money, and then they're not anywhere. And I know you guys are litigators. Everything sounds fine and dandy when things are good, and
It's like a
so if you
marriage.
don't, yeah, if you don't set it up
Exactly.
front, right, it's going to cost you way more, like
Oh
down
yeah.
the road. And I could actually
We
speak from experience.
We
we
tell
make some,
our,
sorry, go
yes,
ahead,
our
Amanda.
clients all the time, like, honestly, or even when we have our client consults, and they ask, well, why do I need an attorney if I can, if Google or this PDF filler online has an agreement? Fine, you can use that online agreement if you want to, if you don't want to spend $1,000 or whatever it is on attorneys. But guess what? When you call me up a few months later, however long, I'm going to make way more money off of you then, because you wanted to do something, kind of half-assed and, in the cheap way. It's going to cost you more in the long run, because the online agreements and contracts and stuff are never fully legally legit and helpful
That
in
is the
terms
biggest
of
mistake.
litigation.
Agreed.
Yeah.
And so you guys actually, I imagine, right, inside of Sunbiz, you guys you don't have to talk about pricing or anything, but if I want to set up a corporation and get that operating agreement, you guys provide those services, correct? In general.
Yes.
Yes.
Okay.
Yeah,
I
we
mean,
do.
you can
And
say
you
that
can,
or not, or
you,
I don't want to,
So
I don't want to hold you to something, but
we don't usually do flat rates for drafting certain operating agreements and stuff, because we don't know how much is going to go into it, how much communications back and forth. If there's multiple partners, what if they don't agree on certain things, right? So it's just a lot of back and forth communication. But if it's a situation where you got business partners, they do business together all the time, or they know exactly what they want, they just lay it out, boom, 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 this is what we need the operating agreement to say, done deal, right? But if you guys are interested in knowing our retainer and hourly rates and stuff, Michelle's hourly rate is $350 minus $315, it goes up to $325 January 1, and our corporate retainers $3,000. Okay, the corporate retainer sits in trust. That's what we use to bill our time against. Any money left over, it's refundable to you, or you just leave it in trust, because literally 99% of our corporate clients always need more help, or you guys are always doing deals, right? Or you want to always be doing deals. And so once you get to that point, you're always going to need someone on hand. Like I said, you need your accountant and your attorney in your pocket with you all times.
absolutely.
But okay, so, and then we'll go over the filing fees and costs for all of that, but I want to go over first single member LLCs versus multi-member LLCs and liabilities and issues that can attach. So single member LLCs do not provide reliable asset protection. So Florida law permits creditors to use foreclosure and other alternative collection remedies against a debtor's interest in a single member LLC. So the creditor must demonstrate that its judgment will not be satisfied in a quote reasonable time from a charging lien. And if you don't know what a charging lien is, I will explain it to you. If they can't satisfy your debt within a reasonable time from a charging lien on a single member LLC membership interest. So in most cases, LLCs designed for asset protection should include at least 2 members. So 2 owners of the LLC. And if you have a single member LLC now, you should really consider having another member added to restrict a creditor to strictly a charging lien. So if you don't have a business partner and you have an LLC that's holding a rental property or something, maybe ask your mom or a friend or someone.
How about me?
And just
wait, no, how about if you guys have a property and assets and you want another member, you could easily add myself or Ryan. I have no problem. I'll go ahead and pay the attorney fee. But no, I know what you're saying is that basically if it's just a single member, the state or the judge per se looks like, hey, you're just you put in this, I guess, entity to kind of hide out, but it's really not, a multi-member.
Yeah, exactly. So, and so you're probably wondering like, oh, well, I don't want to just give my friend 5% interest, ownership interest in this LLC or this property or whatever. But that's why you have operating agreements, the operating agreement, and you can create an operating agreement before or after, anytime, after or before your formation of the LLC. So if you want to add your mom, let's say, or your sister or brother, and you just want to give them like 5% membership interest in the LLC, just to make it a multi-member, right, for better protection. The operating agreement, we can structure it so that your mom doesn't have any voting rights, doesn't have any say in the company or anything like that. So you can still be in charge, you can still have your property, but you just have that extra level or blanket of protection. Also, and just to briefly mention, single member LLCs, I don't believe are eligible for the S Corp tax treatment. So if you had a single member LLC, you'll have to report the business's profits and losses on, I think it's like the 1040 IRS form. And you must also pay the self-employment taxes on all taxable income from the business. But talk to your accountant about that. But back to liabilities, regardless of any of the LLC protections that we just went through, you, the investor, may become personally responsible for some or all of the LLC's debts and liabilities if you or another member commit fraud or other illegal business activities. If you or another member does something to compromise the line of separation between the business and your personal transactions. So I don't know if you guys have ever heard of like piercing the corporate veil, but if a member, let's say you were to co-sign or guarantee a business loan on behalf of your LLC, and then you end up defaulting, that creditor now you are personally on the line. Your personal assets are on the hook to satisfy that debt. So you just always have to keep your business transactions and your personal transactions separate. Also, another way that you can become personally liable is you or another member of your LLC has not managed the LLC according to the operating agreement. Well, actually, yeah, I'll bring that up. I'll talk about expulsion of a member and dissociation of a member when we go through what are the most important terms to be included in the operating agreement. So in Florida, when you have an LLC, you have to file an annual report every year. You file it between January 1 and May 1. I think it's $138.75. I just filed ours not long ago. But if you file it after May 1, then you're hit with a $400 late fee. So just file your annual report or have your registered agent file the annual report or your attorney. And just as a side note, our firm can serve as your registered agent if you need one, even if we're not your lawyers. We can also be your registered agent, and we have two options. So if you want to just have us listed on Sunbiz, meaning we are making ourselves available to accept service on your business's behalf, it's $100 a year. But if you want us to be a registered agent, accept service on your behalf, like when I say accept service, I mean like if you're sued or something, or someone's sending a notice, to your business, they send it to us, and then we give it to you, touch base. But we'll also file your annual report, which is what I'm talking about here. So that's $350 a year. That includes the filing fees and all of that. So you can retain us to just do registered agent services if you like. And to fill out the annual report, it is easy, as long as you know if there's no changes to be made year after year. Just make sure if you are doing it by yourself, you do follow the steps on Sunbiz, and you do know how to properly record whatever changes you may have in the business. Like if you added a new member, especially if you're a single member now and you want to add a member to make yourself a multi-member LLC, make sure you do it properly or have someone do it for you who knows what they're doing. Articles of organization, that's another requirement that you need to file on Sunbiz to have your entity set up. And I'm going to share real quick with you. This is what it looks like on Sunbiz for your articles of organization. So you're going to go on the website, you'll go to the forms, you'll click LLC, here's some instructions, and it's super easy. It just goes over all the articles, what you need to include. There's a cover letter. You put the name of your LLC, like your new business name, your contact information, or if it's us, it might be my contact information or Michelle's. It's $125. You don't need, some people think, oh, I have to order a certificate of filing. You don't need any of this stuff. We usually don't order that for our clients unless they specifically request it, just because it's not necessary and costs them extra money. This is where you fill out Article 1, the name, Article 2, your principal office address, your mailing address. A lot of investors, they don't have or need even a virtual office space or a regular office space. They just use their home address for their principal place of business. That's fine, but just know it will be public record on Sunbiz. Your registered agent, they have to sign here. They have to accept the duties and responsibilities as a registered agent per Chapter 605 of the Florida statutes. So make sure you have your registered agent on there. And here I was just kind of playing around. Let's say Anish and I are forming this LLC. We'll both be members, which means we're both authorized to make decisions on behalf of the LLC, all subject to the operating agreement, right? But the operating agreement is not public record. It's not on Sunbiz. It's private between you and the partners. So a name, address, contact information, or a manager. You can have a manager running your LLC who doesn't even have to be an owner, right? So you could have, you could list, I don't know, maybe your brother, you want to give him a job or something. And so he's the manager, he's running your business, but he doesn't own it. You can have that. And then you just sign here. Super easy, $125. All right, get out of that. Okay, so in addition to setting up the LLC, filing your articles of organization on Sunbiz, you also need the operating agreement drafted, and you need it to be signed by you and your business partners. And an operating agreement is a binding legal contract between the members of an LLC that sets forth the rights and obligations of each member. So an operating agreement outlines the fundamental functions of the LLC, how the entity will be managed. It basically saves you a significant amount of money and time if a dispute arises in the future, because all of the terms in which your business is supposed to and meant to function are already laid out in the contract. And the operating agreement also has ways to resolve the issue as opposed to spending thousands of dollars in legal fees to resolve a matter in litigation, fight it out in court. If you have a clear and concise, properly drafted operating agreement where the judge can just read it and say, oh, in this situation, this is what's supposed to happen. So if this, then that, what is there a fight about? It's already in place. You already agreed to it. You already signed it. It just is a lot cheaper. It's a lot easier for everyone involved. And the good thing is members of an LLC can adopt an operating agreement, like I said, anytime before or after your LLC is created. So if you have an LLC right now and it's you or you and your partners, and you're without an operating agreement, please get your lawyer to draft one and sign it. And it, like I said before, it's literally like a prenup for marriage. People never think they need one until they do, or they never need a lawyer until they do. Just be prepared, you know, preventative maintenance, be, you know, proactive. That's the best way to, you know, run a business. Operating agreements are also necessary to avoid uncertainty between the members and to hopefully reduce the likelihood of litigation. And so even if you have a single member LLC, you should still adopt an operating agreement because one, it will help the LLC avoid the default provisions of Chapter 605 of the Florida statutes, and it can help with asset protection issues. So the adoption of an operating agreement can be used as evidence that the LLC is truly a separate and distinct entity from its owner, from yourself, and not just an alter ego of yourself. So it will provide evidence, so it makes it harder for creditors or whoever wants to sue you, your crazy tenant. It helps as evidence to show that you're separate from the LLC to protect your personal assets. Also, an existing operating agreement can help with the growth of an LLC because an operating agreement should, if it's done properly, should provide the structure for how new members or investors can be added, how they'll be treated, how they'll be paid, etc. Right, so I'm gonna pull.
How about, I'm gonna give you a quick break for a second. So I'm gonna kind of do some rapid fire questions because we got a bunch. So you're gonna make them quick. So I'm gonna ask you the question. So don't worry, I got you on this.
All right.
Is a single member LLC the same as a sole proprietorship?
Michelle, do you wanna
Yeah, no, it is absolutely not, because even though as a single member LLC, creditors do have the option of obtaining a charging order to go after your personal assets, it's still a very high burden and threshold that they have to go through. In other words, it's a hoop that they have to jump through versus sole proprietorship. You have absolutely no legal protection afforded to you by the law. You are essentially hanging yourself out there to the world saying, if I screw up, come sue me. So it's
and I'm going to talk about sole proprietor. I'm going to talk about that later.
Okay.
As well. So
Jack's asking, what do you think about land trusts for asset protection versus LLCs, I guess?
So as far as trust versus asset protection, that's a loaded question. I would definitely recommend setting up a consultation for, but I can answer this much. It depends on what type of trust it is that you're setting up. If it's a revocable trust, you still have, or the guarantor and beneficiary guarantor still has the option to make changes to that trust so the creditor can access it. If it's an irrevocable trust, not so much, but the legal protections are slightly different for a trust than an LLC. Although a trust may be, depending on the circumstance, a great vehicle for setting up a real estate investment company, more often than not, the LLC is still going to be your best option, both from a legal standpoint and from a taxation standpoint.
So you're saying is I should just give you all my information and you'll tell me what I should do?
Sure.
Because that's like, yeah, absolutely. So again, remember, I know some of these questions are specific to your situation. Make sure you reach out to these guys. Sharon's asking, if I want to operate only a single owner, am I better off as a corp? I think you kind of answered that.
So I would say no, from the legal standpoint that, like we said, we don't like the fact that in Florida for now, which by the way, Amanda and I are very involved in the business law section of the Florida bar, which is the section of the Florida bar responsible for working with the legislators to set up all the statutes, and we are in the process of fixing that problem. But even with that said, when it comes to S Corp versus LLC, even though, as Amanda said, I will repeat, we are not tax attorneys and we are not CPAs, because of things like the 1031 exchange and, you know, capital gains, you are still going to be better off as an LLC versus an S Corp.
Perfect. Can you elect for S Corp after 75 days? So
Not to my knowledge.
Okay.
Yeah.
Let's see. Can I list this business as a DBA under an existing LLC, or do I have to have a separate one? So
Amanda,
Stephanie's-
go for it.
You can do a DBA. You just have to file that on Sunbiz. But one thing, just to be careful, and this is it depends also in terms of liability, because I don't know what assets your LLC already owns, if any. And so I am going to get into that in terms of whether you should have like separate LLCs for each investment property or type of investment property, as opposed to just having one LLC, whether it's a DBA or not, owning all of your properties. But you can register, you can have a, like for instance, Michelle and I, we have Florida Entrepreneur Law PA, but we just registered our DBA to drop the PA and just have Florida Entrepreneur Law. And it's easy to do. All you have to do is just publish it in a newspaper, because Florida statutes, Florida legislators are like dinosaurs. So they still require it to be published in the newspaper. And that's something that we can do for you, but it's like $100. You publish it and you can hold your property under your DBA, but again, it's case specific in terms of liability.
And Yara's asking, if I want to sell my house on my own without a realtor, can you help me with the paperwork? And the answer is yes, I could even help it. These guys are attorneys, so they can help you with contracts, anything you need to review. So let's see, Ed's asking, don't you have to pay me this? Oh, no, go ahead. Yeah.
Hold on, Ed. One more thing. So I just got recently got my title agent license. So in the next, I want to say like 30 to 45 days, I'll have the software set up, and so we should be good to go. My goal for the firm is to create a one-stop shop for you guys. So as investors, you can come to us, we can set up your entities, we can draft your agreements, we can draft your purchase and sale contracts, whatever you need, lease agreements. But then also we can represent you at closing. And then I'll go into, actually, I'm going to close this webinar with why you actually should have an attorney represent your interests at closing. But so pretty soon we'll be a one-stop shop to do your closings and handle your transactions for you.
Yeah, so that's a big yes.
Yeah.
Ed's asking, don't you have to pay municipality taxes for LLCs depending where you form it in Broward?
So it's not LLC specific, it's business entity specific. And yes, it depends on your city, it depends on your municipality. You know, some cities and counties require, actually cities and counties, because some counties don't require it and some do, and some cities do and some don't, vice versa, as far as just operating a business within the city limits. So again, that's going to be a fact specific question.
And Garati's asking, what about buy and hold investing? Can you transfer a property to an LLC if the property was purchased under your personal name and still has a mortgage?
Yeah, of course. But the question there is going to become, what does your mortgage paperwork state? Because trust me, your bank is not going to feel comfortable just switching from you, where you are personally liable on that note, over to an LLC, especially if it's a newly established LLC. A lot of banks like to see 2 to 3 years of credit behind the EIN associated with that business. And in either event, they'll still run the credit of the owners of the entity.
Yeah, and also there could be a due on sale clause. And the other thing is you are going to have to pay stamps. So if you do have a mortgage, that's part of it too. Depends on your lender. So I know that's kind of one of those things out there it can be done, or do they often? I can just tell you from my own experience, very rare. Actually, I don't know anyone that they actually did a due on sale clause. The issue usually happens when you don't make payments, but you know, they can go after or do on sale close, which means you got to pay it off. So I know as attorneys, we'll say one thing, I'm just going to tell you what other investors do, you know, so you're going to have to kind of figure out your own risk reward, but she is exactly right on that. Adrian, who should be the registered agent, a lawyer, banker, mother? Depends on you. That's what I would say. You could have any of them, actually. I mean, if you get served.
It's your own registered agent as well, but you just have to have a business address. Well, not a business address. You have to have an address that's not a PO box, and you have to be available Monday through Friday, like regular business hours, to accept service. Meaning, if you know you're expecting to get hit with a lawsuit, you're the registered agent for your company. You can't go trying to dodge service because you're the registered agent. You're supposed to accept the service. So you can serve as yourself, but you can also have a family member or your attorney, whoever.
Perfect. And Wayne's asking, does the second member have to be in the state of Florida? So I'm assuming for the multi LLC, state of Florida for a Florida LLC. So if my mother lives in New Jersey, can she still be?
Yes.
That's okay. Perfect. And I'm only going to get maybe one more so I could kind of get you back. You know, that's why we're kind of doing this kind of rapid. Can a land trust be the second member or registered agent of an LLC for better anonymous?
As far as a registered agent, the question is going to go back to what Amanda just said. Are they available for service of process during service of process hours required by the statute? And then as far as being a member, yes, they can be a member.
There you go. Okay, I am going to let you get you guys off the hot seat a little bit because I know Amanda has some more information. Michelle, you out of here?
Yeah, I'm gonna head out, but thank you everyone. This was awesome. And Amanda,
Michelle.
You're killing it. I'll see you everyone. Best of luck with all of your investment deals. And I hope that we see some of you around again. Bye.
Absolutely. Thanks for joining us today.
All right, guys.
The floor is yours, Amanda.
Okay. I'm gonna pull up a screen here. I'm gonna go over, we don't have enough time to go over everything that should be included in an operating agreement, but I'm gonna hit like some of the most important terms that should be in there, and then I'll explain why. All right, let me do this share screen thing. There we go. Okay. Maybe.
Yeah, you're good.
Okay. In the operating agreement, you want to have ownership interest of each member. So let's say you are adding your mom as a member to make it a multi-member LLC. You're going to want to, or you have your business partners, right? There's 3 of you. One of you own 50%, and then your other 2 business partners own 25% each. You want that reflected in the operating agreement. So you guys know, or so it's written how much ownership interest you have. A description of how the LLC will be managed. So are the 3 of you partners going to manage the LLC together? Meaning you guys are doing the day-to-day business operations. All 3 of you are pitching in to get your title agent, get your attorney, hire contractors, subs, monitoring the job. You also want to include in there, what are the voting rights of each member? So do you want certain actions to require unanimous vote? So for example, you have you and your 2 buddies are business partners. You own 50%. Your other partners own 25% each. And the one that owns 25% says, hey, you know, I saw this great deal. It's up in Tampa. They're only asking, you know, $90K for the property. The ARV is close to like 180. And the prior investor who had it started the flip and the rehab but couldn't finish it. So I'm going to go put an offer on this property and then take money out of the LLC bank account to go purchase that property. But you're like, no, this isn't a good deal. I don't want to do this. Or no, we're not going to do a rehab in Tampa when we're, you know, down in South Florida. you want to make sure in that operating agreement that all three of you business partners know who can make what decisions and on what basis. Does it need to be a unanimous vote of all three of you to put an offer on a property, to incur more than $5,000 in debt on behalf of the company, to sell a property that the company owns, right? So those are things that the voting rights of each member needs to be set forth in the operating agreement. Compensation, you guys all want to get paid. So who's going to make what, how much, when are distributions of profits going to be distributed? So is it going to be, you guys take a distribution after every flip? If your LLC holds a rental property, are you going to take a distribution at the end of every month and just split the, I don't know, the $1,500 you get in rent every month per tenant? That will be set forth in the operating agreement as well, or should be. And yeah, any requirement regarding the contribution of additional capital. So capital calls. This is super important because let's say you're doing a self-funded rehab, or you have a hard money lender, but they're only funding 80% of your flip, and you guys have to come up with the other 20%, right? There's three of you, and let's say you guys need to come up with $15,000 out of pocket. In addition, or let me back up. You guys come up with the 20%. The hard money lender comes up with the other 80%. For whatever reason, something goes wrong with the rehab, you have unexpected costs, and you're not going to borrow additional money from a lender. If you don't have to, because you want to pay interest and all that, you want to just make a capital call, meaning the three of you agree, okay, we need $15,000 to fix something that was unexpected with the HVAC or the pool or whatever. You each need to put in $5,000. And one of your business partners says, no, I can't put in the 5,000, and they default. They're called a defaulting member or default member. So what happens when now you and your other business partner have to come up with that 15K together? And that defaulting member, what, they just don't have to pay? No. The operating agreement can set forth whatever term you want. Maybe the defaulting member contributes more labor instead of capital. So capital doesn't have to just be a monetary contribution. It can be a labor contribution, or you can give them 30 days, 60 days, 90 days to repay you guys the amount of capital that you had to front for them. And then if they don't pay within that set time period, parts of their interest starts getting diluted over time, right? So you can structure it however you want. The important thing is it just needs to be set forth in writing, signed by everyone. So that way you're not getting screwed and everyone's, on the same page in terms of their responsibilities and consequences should they default. Any requirement, ability of members to transfer their membership interest in the LLC. So you and your two partners, you've been in business for a while, and then one of your partners wants to get out and they want to transfer some of their membership interest to a buddy of theirs who you don't even know. You don't want to do business with them. You don't want to own a property with them, or maybe you just don't like them. The operating agreement is going to prevent your partner from transferring any of their ownership interests in the LLC to someone else without what usually we recommend, a unanimous vote. So if all three partners agree, hey, yeah, Joe, you can transfer some of your interest to John, it's no problem, fine. But if you don't want John involved, then the operating agreement sets forth parameters in which approval that transfer has to meet. This one's huge. So disability of a member. No one thinks that they're gonna walk outside and get hit by a bus or in a car accident, or they develop a disability, but it happens. And so let's say your business partner becomes disabled. How we usually recommend for our clients and how we structure their operating agreements is you're considered a disabled member when you can no longer do the duties and responsibilities that you have for the company, right? So usually if you're disabled for 6 months or more, your legal guardian whoever's taking care of you, sometimes it might be your spouse, they will have to offer to sell the disabled member's interest in the company to like sell it back to the company or sell it to you two. So let's say you and your partner, but then the third partner becomes disabled. That partner, that disabled partner's legal representative who's caring for them has to offer to sell back to the company their interest or sell back to you and your partner their interest. Or if you guys don't want to buy their interest back or the company doesn't want to buy their interest back, it'll just sit in there, then they will still be able to collect distributions. So they'll be responsible for profits and losses on behalf of the company, but they are now considered to have a transferable interest. So they do not participate in voting, day-to-day operations. They don't make decisions. They're disabled. They can't. So, but they do get rights to profits and distributions. Or you set it up where it's a mandatory sale and you guys buy their interest from them. Death of a member. So if you guys are holding, you have long-term holds, investment properties, you and your business partner, and your business partner or you passes away, what happens with their interest? You don't know unless they have a will. But if you have an operating agreement, how we usually set it up is that upon the death of a member, the deceased member's estate shall mean must, means have to offer to sell the deceased member's interest back to the company or back to the remaining members. So that way it doesn't just pass to their heirs. And then if the company or the members don't elect to purchase, then it becomes a transferable interest. So let's say your 25% partner passes away. You don't want to buy their membership interest. You want their kids to have something. So whatever, it passes to whoever it is in intestate or through will. And they have a transferable interest. They can't participate in voting. They don't make decisions. They just get profits, distributions, losses. So they have no say in how to run the company, what properties to purchase, when to sell. You can sell the property anytime. They would just get a portion of the sale proceeds, depending on how it's structured in the operating agreement. But you need to have something in writing that deals with death of a partner. Divorce. What if you get a divorce and you don't like your ex-spouse, your ex-wife, your ex-husband? They had nothing to do with your real estate investing. You have this awesome portfolio, you and your business partners, but then you get a divorce and the court orders you to transfer or to give your ex-spouse a percentage of your ownership interest in the LLC. And now you're like, oh my God, my ex-wife is gonna have voting rights, is gonna be able to decide which properties we invest in or which properties we don't invest in. No, it doesn't work that way if you have a properly drafted operating agreement. The operating agreement will, whatever percentage the court requires you to transfer to your ex-spouse, if any, that ex-spouse will only have a transferable interest, meaning they cannot participate in the day-to-day operations, voting. They have no say whatsoever. They're just silent. They collect their profit, loss, distribution, check, and that's it. But if you don't have that in writing, it can get pretty ugly. Dissociation of a member. So earlier when I mentioned if a member does something illegal or wrong on behalf of the company, or let's say they commit fraud. Let's say one of the 25% partners commits fraud on behalf of the company. Well, you and your partner aren't going to want them involved anymore. You don't want him as a business partner or her. So they get voted out basically, and it's called an expulsion. So they're an expelled member, and the operating agreement sets forth the terms that would trigger an expulsion or a dissociation of a member. Also, what if one of your business partners are like, you know what, I want to retire, I'm good, I don't want to keep working, I don't want to keep finding deals, and they just want to leave the business, they want to dissociate. The operating agreement sets forth ways in which to do that. Okay, I'm going to stop sharing.
Yeah, so I mean, like, you know, what I'm getting more than anything is the idea is to be proactive so that in case something goes wrong, and there's things like, you know, you're not thinking about death, you're not thinking about divorce, being a partner with, you know, Amanda doesn't want to be partners with my wife, right? Or vice versa, or whatever that is. And you don't really think about these things. And as you're building wealth, it could literally, and I actually know a member that actually lost everything in a divorce, all his properties, and he had a partner, he had a payout, and it was a disaster. So I always think that it's important to set these things up front. And these are the tough questions that, you know, most people don't think about. They're, you know, hey, I'm excited about real estate, I want to get my business going. What do you do when things go wrong? So I think when it's spelled out from the beginning, it's going to save a little bit of a heartache is probably what I would say, and because
A
it's going to
lot.
be spelled out.
Yeah.
You know, so,
Okay. So bottom
what,
line, just get a freaking operating agreement drafted. Don't get it from online, because then if something goes sideways, which often happens, especially in real estate and flipping, and you just never know. So just protect yourself.
yeah. So what we're going to do, because of time a little bit, we're going to kind of just chat about, I mean, I know you're going to hit it on this anyway, right? Meaning properties. So the big question I always get, you know, should I have a separate LLC for each property? Or do I put 10 in or 15 or, you know,
Yeah.
so I guess, what do you see with investors when you're, and again, your situation's always different. What do you
Yeah.
generally
So
say?
that is a loaded question. I am going to go through that, so I'll just do it now. There's a couple different ways to set up your business structure. You can do one where, let's say, you have just one sole LLC that holds all of your properties, right? There are a few pros to having all of your investments under one entity, but there's also a huge risk. So the pros with that is you only have to file one articles of organization. So you only have to pay $125 once. There's no business tax return. And so each LLC member has just one business that passes through its income and losses, taxes through their personal tax return. And then the other good thing is the owners only need to maintain compliance for just one entity. But really the huge risk and downside to having all of your investments under one LLC is if there's a lawsuit targeting one property, guess what? All of your properties are targeted. All of your properties are free game. So I don't know why you would want to do that, but if you do have it set up that way, we should probably talk. Another way is to do separate LLCs for each property. So here, each property is under its own LLC. So because each LLC is an individual legal entity, the properties that are protected from, or the property in that LLC are protected from other properties and other, what am I trying to say?
From lawsuit. Yeah, no, I mean,
I lost
that's
my
why
train of thought, but
I got you. I know what you're saying is that basically if you put each property separately, right? And let's say that tenant at that house
right,
has
they
some
can't
major
for
issue.
your other assets. They can, it's only, that lawsuit is only subject to that one property in that LLC.
Yes.
The
So
only thing is obviously there's more formation costs and filing fees. So you have to file an article of organization for each LLC. So $125 times, if you're doing 3 flips, then 125 times 3.
yeah, and also on your accounting too, right? You're gonna have to file different probably tax returns for each corporation too, depending on what you do. There is a way that to have an umbrella to cover everything, but that's more of an accounting question.
So another way is a Series LLC, and that's for multiple real estate investments. So a Series LLC refers to like an umbrella LLC with separate LLCs that fall underneath it that hold each property. So I actually made a slide for this. See. Okay. Share. Okay, so this is what a Series LLC structure looks like, more or less. So you have your parent company up here. This LLC owns these 3 LLCs here, and each LLC individually owns an individual property. And so the good thing about doing it this way is you only have to file 1 articles of organization to form the Series LLC. However, each LLC in the series operates as a separate entity. So each LLC in the series will have its own business name, its own business bank account, and it must maintain its own records. So the individual series assets, liabilities, operations, membership interests, they're all independent and separate of the other series under the umbrella LLC. So the only thing with this though is that Florida does not recognize Series LLCs yet. However, I know our investor clients, they often use Texas or Nevada or Delaware to register their Series LLC entities, but then they can buy or invest in Florida. And we often work with out-of-state attorneys to help structure our clients' deals. So if you want to do that, set up a series, you want to do it in Delaware, cool, we can help you with that. Just know that you need to do like a cost benefit analysis, because you should compare how much it will cost you to form an individual Florida LLC for each property. So let's say you have 3 properties or 3 flips going at once, and then you have you have a rental property, so you have 4. And you have 4 LLCs, that's $125 times 4, and then you have your operating agreements. But just the filing fees alone, make sure that you check with the state that you want to form a Series LLC, what their filing fees are, what their compliance, like cost for compliance and all is. Definitely more of an accountant or a question for your CPA. But we work with CPAs all the time, so we can figure out what is the best structure for you. Okay, Anish, I was gonna go into charging orders.
Do you want to, because you got a limited time, do you want to just give a general what a charging order is and how that could affect you as a real estate investor?
Yeah, so your membership interest in a Florida LLC is not considered an exempt asset under Florida law, but creditors have limited ability to collect a judgment of a debtor's LLC interest. So Florida law provides that a judgment creditor can seize or garnish or cannot seize or garnish your ownership interest in your LLC. And they have no ability to attack your assets, your financial accounts, your the real estate that you own in the name of the LLC. So in a properly drafted operating agreement, a creditor is not able to inspect your LLC's financial records, and they're unable to participate in the management of your LLC. So instead, a judgment creditor's rights are limited by law to what is called a charging lien or a charging order against your LLC or your partnership interest, limited partner, whatever deal you have. So the creditor, they can seek a judgment or they can seek a charging order from the court which then gives the creditor a lien against any distributions of cash or other property, if any, that the LLC makes or owes to the debtor. So in other words, if the LLC does not distribute money, then the judgment creditor receives nothing. So for example, if you have a rental property or a multifamily under the LLC and it's generating $5,000 a month in passive income, and you have a charging order or a lien because a creditor sued your business, if you don't take a distribution, like monthly, quarterly, whatever, then that creditor gets no money. I mean, you don't get money either because you're not able to take a distribution, which sucks, but at least your money is staying in the account until you have enough money to pay or negotiate a settlement with the debtor. But my point is, they can't just garnish your assets under the LLC with a charging order. They can only attack your distributions, like the cash that's coming out of the business to you.
Yeah, I was going to say the easiest way, your problem's not going to go away, but they can't dip into your pocket.
Exactly. Yeah.
I always have to make it a niche proof to make it easy.
Yeah.
But that's what I get out of that, is that basically, you know, the idea is you're gonna have to still deal with it. It's just that you're not gonna get any money right away. They're not gonna get any, and they can't literally go into your bank account to take it.
Yeah. Okay, and let's see, how much, we have 10 minutes, right?
We got about 10 minutes. So
Okay.
how about, why don't we do this kind of a little bit? Do you want to kind of just recap? Like, let's say I'm a new investor, right? So I'm not going to open a sole proprietorship. I'm going to open up a multifamily LLC, right?
Multi-member.
Multi-member, sorry. If I'm the only one, you could add Anish or Ryan as your member. I'll give you my information. Or you could always use a family member or someone you know. The key is to have an operating agreement, right? And the operating agreement will basically say what? It's going to spell out everything.
All the terms, ways in which the business entity is meant to operate. Basically, if this happens, then this. If this, then that. If something goes sideways, if your partnership, falls and you no longer work well together, or anything can happen. It's in the agreement. It tells you what needs to be done, what to do. And a good one is not vague, it's not ambiguous, it's not overbroad, right? And if a judge were to read it, because let's say your partner sues you or whatever happens, and you end up in court, you're going to say, hey, judge, but I have this operating agreement here. This is what so-and-so agreed to. Here's what it says. And if the judge reads it and it's simple enough, the evidence is there. If you have a vague operating agreement with ambiguous terms, like what you get online and stuff, the judge is going to be like, well, this can be interpreted in 3, 4, 5 different ways. And guess what? You're going to stay in court. You're going to stay in litigation. You're going to spend more than 10,000, sometimes 20, sometimes even more than what you invested in the property or the business to begin with, all in attorney's fees, which is fine with me, but I would rather just help you draft the operating agreement from the start, and then you're good to go and you're in business. So
yeah. So and again, like the key points that Amanda was talking about is like things that I wouldn't even think about is like fraud, that kind of stuff, divorce. So that's why you want to make sure that operating agreement is really to the point in case something happens. Also, if you own multiple properties, right? So you have a couple different things that you could do, right? She talked about the Series Llc. So you could do it that way. You could put them all in one. It's going to be the cost of, what's it going to cost you to have all those corporations up, the accounting services, and then also your risk. So, I mean, if you have 100 properties, I highly doubt you're going to probably get 100 LLCs because the cost may add up, right? Unless you're talking, multi-million-dollar properties on each one, very different. But if you're talking smaller homes and your cap rate, you're making, 500-600 a month, after everything, that might eat up all your costs. So I think it always just becomes a balance on as an investor and what you decide with your attorney and accountant
Yeah.
too, right? And
Yeah.
then the other thing I was going to say is since, and we're talking about charging orders, you want to, the last recap on charging orders, one good thing or what to look out for maybe?
Sure. So with charging orders, well, what do you mean by what to look out for?
Well, I mean, like, what's the best way to protect it? You know, is there anything that you would suggest that, you know, the formation, I guess, would be?
Yeah, so an LLC will protect you. I mean, honestly, there's no entity structure that will like fully protect you from having to pay a debt. I mean, I know some people, they just file for bankruptcy, then they shut down the business, they dissolve. But if you have an LLC and you haven't, your creditor can't pierce the corporate veil, right? Like they can't prove that you mixed personal transactions with business transactions and so on, then the charging order is really just a lien. Like you're gonna have to satisfy the debt one way or another. But if you have your LLC set up and you're properly protected, you have your operating agreement in place, then that sets forth how to deal with liens and whatnot. You'll be fine, but you're still gonna have to satisfy your debt in some way. But just protect yourself with having your LLC, particularly a multi-member LLC, not a single member.
Absolutely. And I know
Um,
because of time, I mean, we could sit here for hours and chatting with
I know,
Amanda
really, but
on that too, but I did have a question. I know about the foreclosure court delays with COVID. What have you seen? Is there anything that you kind of want to maybe touch on?
so
Um,
yeah, so I don't practice in foreclosure court. I'm just not dealing with foreclosures right now, but some colleagues of mine, they did say the courts, I mean, all the courts, regardless of whatever division, they're super backed up. They just had their first jury trial in Broward last week, like in person. So I think Palm Beach and Miami Dade, I don't think the courts are accepting writs of possession yet. But there is a backlog. So I was hoping to get a more clear answer from my colleagues this morning before I jumped on to see if they've had, their hearings and, postponements, pushback, like how far in the future, but I haven't got that answer, but I'm happy to follow up with you guys and then you guys can let them know.
Absolutely. And the other thing is, remember, like HOAs, they're still foreclosing. So it's not, I know there's a moratorium. It's mainly for Fannie Mae, conventional, FHA, but private loans, they're foreclosing. So it's not everyone that falls under the moratorium
Yeah.
in general. And the last thing I know we kind of didn't touch on, but why should you consider an attorney for real estate closings?
Yeah.
So versus, for investment properties, you want to kind of talk about the difference that, that what you do?
Sure. So when you hire a title agency company, they don't represent the interests of the buyer or the seller. They're just there to be like the neutral middle party, do their job, close the deal, right? But in Florida, buyers and sellers, they're not required to hire an attorney for closings. But as an investor, it's important to ensure that your investments are protected always, right? So some investors, they specifically focus on REO or foreclosure properties. However, what a bank must disclose in these types of sale transactions may be different from what a private party would need to disclose for that type of transaction. So I made a slide, but we probably don't have time to go over it, but there's,
If you want to
I'm
just
gonna
throw it
just,
up for a second, because remember,
yeah,
guys, just so
share.
you guys
But
know, this recording will be on our YouTube channel within 48 hours. I know people have been private messaging me about slides. This will be up there also.
So here, I'll leave this on here. We didn't get to talk about as is contracts, but if you want to take notes real quick, these are things that must be, they're mandatory disclosures that have to be on the as-is contracts. And so I highly recommend that you have an attorney review them before you sign anything. But, all right, so documents necessary for real estate closings. All of these documents, and not everyone knows that, but the attorney who handles all of this paperwork for you, they'll conduct a title examination beforehand to make sure that you have clear and marketable title. And so unlike your own attorney, like I said, the title insurance company, they conduct the title examination, but they don't represent the buyer's interest or the seller's interest. And they can't provide you with legal advice about the consequences of issues that arise during a title search. And also the purchase and sale contract, that should describe the price, the covenants and restrictions, defects, easements, dates of various deadlines, all of which your attorney can advise you on, unlike a real estate agent or even a title agent. So that's why it's important to have a real estate, or to have a real estate attorney there with you at closing to represent your interests, especially if it's been like a complicated or complex transaction.
Yeah, and my fellow real estate agents like myself, please do not give legal advice, because you could be on the hook. Not only you, your broker. It's a quick way to be out of the business, right? So you always want to, pass it on to attorneys, let them give the legal opinion of what's happening, because I think that's a lot of mistakes that I see with agents in general. That I know you want to help out your client and you're trying to save them a couple bucks, but you give the wrong information on anything, it's going to cost you a bunch of bucks on liability too.
And I'll share a quick story with you about a client. It'll only be a minute. He bought an investment property, rented it out to a young guy, a tenant, model tenant, $1,200 security deposit, $800 a month in rent. This was North Florida. And he went online and picked out one of the lease agreements that are on Google and he filled in his name, tenant's info, address, all that stuff. And then model tenant paid rent on time for a year. Then after a year, the tenant decides he wants to marry his girlfriend, and then they want to move in together somewhere else. So he does not renew the lease and he requests his security deposit back. The landlord, he's like, okay, so he goes and he looks at the rental agreement that him and the tenant signed, and he's like, all right, cool. I got 90 days to return this $1,200 security deposit. Well, it was like 83 days later, so like a week before the 90-day period, client gets served with a lawsuit for not returning the security deposit. And he's like super confused because according to the rental agreement, he had 90 days to pay, he still had a week left. Well, what he didn't realize, and what the contract online didn't show him, was Florida law requires security deposits to be returned within 15 to 60 days, depending on situation, of the tenant moving out. And so, and also the lawsuit pointed out that the investor neglected to include a copy of Florida statute 89.43 in the lease. And that's required by state law too. So he didn't know that he was supposed to do that either. So he defaulted, and he didn't follow two laws there. So the client, he not only found himself in court and he had to pay a ton of extra money on legal fees, court costs, etc., but all because he just wanted to do Google University, instead of hiring an attorney. And then so when you screw up like that and then you hire an attorney, you're going to pay a lot more. So that few $100 or whatever it would have taken us to draft a solid lease agreement, he now had to pay thousands to defend in court, pay court costs and stuff. So
yeah, plus the headache. I mean, the obvious, right? Like not only the monetary, it's the time and the agina, the stress of dealing with that. So, I mean, there are a lot of things, you just want to be protected and make sure what Amanda is really talking about, having the right team, so you want to, again, when things go wrong, that's when the issue is. if the tenant's paying, this is great. Hey, I don't need to do this. I have it in my personal name, the rental, the property, nothing's ever happened to me. That's a different conversation.
Yeah, but then
One big,
tenant slips and falls
and
and sues you.
one big mess up and you're done, right? You work very hard to build your business. So just make sure, again, you have someone on your team. Amanda is one of our newer corporates, even though we've known her for years. Her information's on REIA.com. Also, we did put it earlier in the chat. Our winner today is Linda Cave, by the way. Hey, Linda, congratulations for the consultations. So is there any last parting word that you might want to give our audience or anything that
I'm just super grateful that you guys came, and I know this is not the most interesting topic for most people, even though it is for me. My fiance hates when I talk about business stuff all the time. But I appreciate you guys being here. I am always available. Just email me. We can set up a consult. If you want to go over anything, I'm happy to help with joint venture agreements, partnership agreements, rental leases, commercial or residential.
Are you also doing mortgage and notes, or is that not something you're doing?
Not yet.
Yeah,
Well,
notes, I should say.
so like you guys, I have a team of attorneys that I work with too. So I'm always working with other attorneys just to make sure that my clients have everything that they need. So
Okay.
really, whatever you need, I can figure it out.
Absolutely. So a couple things. First of all, I want to thank everyone for hanging out. I know we ran a couple minutes late. Thursday, we also have our next event with REIA. If you want to get in the Airbnb business and see the software we use to kill it. Next week, we also have our member benefits. If you're not a member of REIA or Miami-Dade REIA, you're missing out on a lot of good, deals, including Home Depot, Rent Perfect, Equity Trusts. So we have a ton of stuff on there. This will also be on our YouTube channel within 48 hours. I always get that. I know some of you guys wanted to see Amanda's slides. So it will be on YouTube also. And once again, I want to really thank Amanda and Michelle. I know she had to leave a little bit earlier for sharing this knowledge. The lucky part for Ryan and I, we get to talk to Amanda and she tells us all these things and we say, hey, why don't you do a webinar? Because there was no way I will remember all the stuff that you talk about. And, thanks for hanging out with us, and hopefully we'll get to see you soon in person. So thank you guys for joining us for today's webinar.
Thank you.
Thank you. And again, the free giveaway, just so you know, or free, I shouldn't say, it's a $300 credit off the first invoice. If you retain them within the first 30 days. She does have a list of all the attendees, so we'll know, or she'll verify with me. So again, thanks, Amanda, and we'll catch you soon. Be safe.
Thank you. See
Take
ya.
care. Bye.